case is 24-1-130234 and 24-1-132534, State versus Ali. This matter is before the court today. The evidence has concluded in this case, and the court needs to address appropriate jury instructions. Ms. Stone and Ms. Zoe are present on behalf of the state. Mr. Kading is present with Mr. Ali, representing Mr. Ali, and Mr. Leary is present with Mrs. Ali and representing Mrs. Ali. Yesterday afternoon, after the conclusion of the evidence, I provided to the parties draft instructions and explained kind of how I put those together. I would just indicate, in case there's any questions, the copies I gave to the parties were double-sided. The original instructions will not be double-sided. I do run instructions continuously, i.e. not a single instruction on each page, but I will never break up an instruction between two pages when the final instructions are put together. As to, and as I refer to numbers, I am referring, of course, just to draft instructions, but I'm not going to repeat the word draft over and over again. So as to instructions 1 through 3, any issues with those, and I don't know if Ms. Stone or Ms. Zoe are going to be dealing with issues related to jury instructions.
I will. I'm sorry. May I remain seated while we have the conversation?
Of course.
Thank you. No issues. What's 1 through 3?
All right, Mr. Kading.
No issues, Your Honor.
Mr. Leary.
No exception.
All right. Number 4. The state and Mr. Kading submitted the same instruction. Mr. Leary submitted an instruction that has bracketed information from the WIPIC, which includes what is often referred to as the abiding belief language, the last sentence. And I have that bolded in the instructions so that it would be clear that that was the issue that I would be addressing. Mr. Leary, I thought I would hear from you first.
As I'm sure everybody is well aware in terms of the arguments associated with WIPIC 4.01, it is not error to include that language. It is discretionary as defined by the comments and by the bracketed material in 4.01. I do object to language where the court is directing the jury as to whether they are satisfied beyond a reasonable doubt. I would also note that in the introductory instructions that the court provided to the jury when discussing reasonable doubt, the court did not include the abiding belief language, which I did note. Would ask them to be consistent and simply object. I'm not aware of this court's policy, and I know that courts generally have a standard policy, so that's my argument.
Thank you. Mr. Kading, your instruction did not include that language.
It might be. The abiding belief, I will not.
I don't think so, but I could have missed it, certainly. I'm looking at your initial instruction, and you included the abiding, so you want the abiding belief
I don't
language.
object to it. I mean,
Okay, because that's what was in your proposed instruction. Yes, so that's, and I apologize if I wasn't clear. You did propose that language.
Right.
Yes, all right. And that's why I indicated on the draft instructions that it was only Mrs. Ali's instruction that had that language. Ms. Stone?
Thank you, Your Honor. Your Honor, I think counsel is correct as to the law regarding the abiding belief language. That is discretionary for the court. Obviously, the state would note that that language is regularly given. It is appropriate to give that language. The state's position consistently has been when we are talking about reasonable doubt, that is not a objective measurement that the jury can look at information and say it's this percentage, there's no numerical value. And while we talk about it regularly as attorneys, especially as criminal attorneys, in the course of the law, that has become, I would argue, a very much more familiarity to it. The first time that most jurors hear that as a measurement for deciding a case is during the course of the actual case when they're on jury duty. So they don't have that same familiarity. The state's position is and will remain that by giving essentially the opposite side of that coin, that helps the jury decide what otherwise could be I don't want to say amorphous, but a oftentimes difficult standard to apply with any level of certainty. So by giving them the opposite of of reasonable doubt with abiding belief, that is the opposite side of that coin, that helps give them another means for discussing with each other if they have a reasonable doubt. I would ask the court to provide that as additional definition for them to help them make that consideration. It is appropriate, it is not error, and I think it is helpful to the jury.
Thank you. Anything further, Mr. Leary? All right. First of all, Mr. Leary raised the issue as to when I gave my opening information to the prospective jurors, to the entire panel, I give them, what I tell them is a definition of reasonable doubt. And Mr. Leary is correct. I did not read the abiding belief language, and I don't ever include the abiding belief language when I give that just general definition to a jury. These are the jury instructions, which are different than the court giving a jury a general idea of how reasonable doubt is defined, and I would posit that no one will remember, first of all, exactly what I said at the time of those instructions. But the reason I don't give the abiding belief language is that I don't want someone who is a defendant to feel that they cannot suggest that if I give it, that means it will be in the final instructions. I want both sides to have an opportunity to argue that to the court, and so I don't want to read that on the off chance that someone would remember that they heard it differently. That's why I don't include it. It allows both sides the opportunity to argue to the court at the time of instructions whether or not I should include the abiding belief language. And I don't like to have a policy as it relates to jury instructions, as it relates to how I give jury instructions. I don't think that's appropriate. I think the court has to decide every time what are going to be the appropriate instructions in this matter. I find, and as the lawyers have properly indicated, if the court includes the abiding belief language, according to our pattern instructions, that's appropriate language and consistent with the law. If the court did not give the abiding belief language, that is also an appropriate instruction and consistent with the law. I am persuaded that it is appropriate, and I will include the abiding belief language in instruction 4. Any issues with 5 through 7, Ms. Stone?
No, Your Honor.
Mr. Keating?
No, Your Honor.
Mr. Leary?
No, Your Honor.
Ms. Stone, any issue with number 8?
My question, if it was necessary, Your Honor, in terms of the state going back through the evidence, I saw statements obviously that Mrs. Ali had made, which have come in, and statements that Mr. Ali had made, or I guess not made, but referenced in terms of arguments between his daughter and students at the scene, but not as it relates to each other, or that necessarily discuss the actions of each other, as the state's position is that Mr. or Mrs. Ali did not reference really her husband's actions at all. Her husband was referenced only in terms of what people were doing to her husband. So I don't think that it's necessary, and I think that it could be confusing to the jury in terms of how they identify what is happening in the case. That instruction number 8 is essentially a rule to address burden, and we don't have those types of statements here. There's no confession statement that implicates their co-defendant in terms of behavior. So I think this instruction number 8 is confusing, and I don't think it fits in this case, even though it is a co-defendant case.
All right, thank you. Mr. Keating?
Your Honor, I don't know what the final argument of the government is going to be, but I think that this instruction is necessary because I know there has been references to which you made after this event that the state has been listening from the witnesses. Obviously, Mr. Ali was part of those.
Bless you.
So I think it's appropriate to limit the statements that she made to be used in arguments in case against her, but not against Mr. Ali. So I would ask the court to include it.
Mr. Larry?
Well, I can think of one example. One, I think it was Officer Bell, Sergeant Bell, said that Mr. Ali told Mrs. Ali to just go home. Given that my client is charged with burglary, I have an argument that she had been trespassed. That statement shouldn't be used as evidence of burglary or trespass, and as to why. I didn't get a chance to cross him on why he wanted her to go home, because she wasn't supposed to be there, or just because the event was over and just go home. So I do think that instruction is applicable.
And so I'm not making that argument, so insofar as that's helpful, I don't think that applies that burglary plainly was committed prior to that statement being made. So I understand that concern. That's not an argument the state's making or would make, and I don't think that makes that instruction applicable. Yes. My concern is that Mrs. Ali describes what she sees as it relates to what is happening to her husband. My concern is that whether the jury looks at that and says, well, then do we need to take what Mrs. Ali said, she says, and cut Mr. Ali out of those observations altogether, even though it doesn't address any behaviors done by Mr. Ali. In fact, it's completely silent as to behaviors by Mrs. Ali, or excuse me, Mr. Ali. So that's my concern, is that it is going to be confusing to the jury in terms of how they apply it to Mrs. Ali's statements about her husband.
What specific statements are you concerned about would be confusing to the jury if this instruction were given?
Yes, Your Honor. My concern is that the way it implies is Mrs. Ali very specifically says she rolled up, she doesn't say roll up, but she and Haneen arrive on the scene, and that she is watching students beat her husband. They're punching him over and over and over again. Those were the statements that she continues to make. My concern is that the jury, in reading this instruction based on essentially the nature of it, that somehow then they have to pretend she doesn't say Mr. Ali and it's just a person or someone else. That they shouldn't use it that way, but because of the way that it reads, my concern is that somehow they will neutralize and take Mr. Ali out of that statement by Mrs. Ali, even though it's not attributing any actions to Mr. Ali, and there's no statements regarding a confession or conspiracy whatsoever. So that's the state's concern. I don't think it applies in this case for those reasons, and I think it can be confusing to the jury.
Mr. Larry?
The state said that they weren't going to argue, but that's not the only standard. You are telling the jury how they are to weigh the evidence and how they may use the evidence. And just because the state doesn't make an argument with respect to the burglary, it doesn't mean that the jury might not use Mr. Ali's statement.
All right. I am going to give instruction number 8. I think it is appropriate under the evidence that has been presented in this case as it relates to statements by the defendants. I do not believe that it's going to limit the state in how they can argue their case and the facts that have been presented in this matter as it relates to each of the defendants. Instruction number 9, the last clause of that instruction, or of a third person, was included in the instruction offered by the state and Mr. Keating. That clause was not in the instruction offered by Mr. Leary, and it appeared to me that it doesn't apply.
The state agrees with Mr. Leary's instruction, Your Honor.
All right, Mr. Keating?
I do too, Your Honor. I only included it because it wasn't bracketed, so it's not relevant.
So what I have bolded in the draft instructions will be deleted. All right, Ms. Stone, any issues with 10 through 12?
Only on 10, Your Honor, I would indicate, I think we need a he or she does any act that is a substantial step.
All right. If I add or she, any issue with that instruction, Mr. Keating? Mr. Leary? All right, and I didn't ask you, any issues with 11 or 12, Mr. Keating? Mr. Leary? All right. Any issue with number 13, Ms. Stone?
No, Your Honor.
Mr. Keating?
No.
Mr. Leary?
Yes.
All right.
So I guess at the outset, as evidenced by the pretrial brief and representations, the state had previously indicated, despite what was in the amended information, that they were not proceeding on an accomplice liability on the murder. I reached out to the state after I saw the draft instructions to say, had that position changed, or was this included in error? And they indicated that they did intend to offer this with respect to the attempted murder, and the specific explanation was based on Ms. Wagner's statement as to the actions of my client in terms of that she saw mom striking the man. And so her testimony was different from that, but regardless, I don't believe that there is. So I just want to be clear that the accomplice liability applies to the attempted murder. Is that correct from the state's perspective?
Yes.
And only the attempted murder. So operating from that. So
No, I mean, she's charged as a principal or accomplice several times. If we're talking about the attempted murder, which I understood the question was, then yes, it applies to the attempted murder, and she has been charged that way consistently. I think that there are two theories that the jury could apply it on, either as a principal or as an accomplice, but both of those are available to the state. And while we did discuss very much earlier on in the case a different scenario that much later in the case, as we talked about it, Mrs. Wagner's information is different, and I think the testimony at trial is consistent with the charging, and the state intends to argue that as well. I think there's two theories that the jury could find that on, based on the testimony that has come out at trial.
I can promise you that. I wanted to be sure that I was only talking the accomplice theory, in addition to the intentional theory on the murder too, is the account of attempted murder is the only account where the state is proffering an accomplice theory, not the assault theory or the unlawfulness. Is that correct, or am I incorrect?
I think counsel is incorrect. I think that both of those apply. I think the stronger argument, certainly for both of them, for the state is the principal, but I think the accomplice liability applies for both. The state would be arguing both of those.
Okay, that's all. Thank you. So, the question then becomes, in the instructions, is there sufficient evidence for the jury to consider my client as an accomplice? And I'll start with the attempted murder too. If we look at the video, we know that in Exhibit 34, you can see at 213, you can see the Honda Element going the opposite direction on Mullen Road from the bus, and it then The bus then parks, and then the Honda Element turns into the parking lot. The Element is already turning into the parking lot while the initial physical confrontation between Mr. Ali and Isaiah Moon. I can see the initial confrontation. So she then pulls into the parking, actually Amin pulls into the parking lot, and on exhibit 114, which is the Timberline High School video, we can then see her running across the parking lot, and there's been no testimony as to what is visible from there. We can surmise the distance. We know there are cars that she's running around, and there are kids surrounding Mr. Ali, Fatima Ali on the ground. We then look at Exhibit 89, which was discussed yesterday, admitted earlier in trial, which shows the arrival of my client standing next to the truck with the large Douglas fir tree in the middle of that still shot exhibit. So we know there's been no discussion about a conversation between my client and her husband about solicitation, a direction, commanding, encouraging, or requesting Mrs. Ali to commit the crime of attempted murder. There's no testimony that she agreed to aid in the planning of the commission of the crime. So the sole question is whether or not she aided Mr. Ali in the allegation that he committed attempted murder. We know that mere presence and knowledge of criminal activity, so more than mere presence and knowledge of criminal activity must be shown to establish that a person who is present is an accomplice. That's in the instruction. So, and then there's case law that talks about it's not known, it's that they actually knew. Now, the state has made a large effort, or has addressed this topic repeatedly, that at no time did my client tell the police to talk about strangulation or talk about or seeing her husband strangle Fatima. She talks about the repeated punches to his head over and over and over again. Furthermore, the court is well aware of the positioning of everybody. So we have Mullen Road, we have Fatima on the ground, we then have her dad either on top or laying in between Mullen Road, so Fatima, Mr. Ali, and the school, the direction in which he's coming. There's been no testimony that, in terms of what was visible from the parking lot, there's no pictures or evidence that detectives went afterward to basically show what is visible from the parking lot. There's nobody says it was very clear from where I was standing next to the truck or between Mr. Ali and the truck that it was very clear that what was happening. What she says is, I could see him being struck in the head by Isaiah. So, the state has to prove that she has actual knowledge that he was attempting to kill her, and that she then, with that knowledge, agreed to assist in the commission of that crime. And there simply isn't sufficient evidence for the jury to be instructed on attempted murder 2 as to attempted murder. So then the next question is, as to assault 2, with respect to strangulation, same argument. She comes up, and we know from Mr. Wagner's arrival, he comes from one side where he can actually see Fatima, intervenes, and his testimony is Dad immediately, he removed Dad's arm with some force, but there really wasn't much of a struggle, and he basically was able to immediately stop Mr. Ali and the actions of Mr. Ali. So then we go to the unlawful imprisonment. Now, the court noted yesterday in the halftime motion that strangulation isn't a part of reasonable parenting. But we have to look at it, again, from the eyes of my client. She sees, presumably, we don't actually even have testimony that she did see, or could see, or made eye contact, but there's an argument, circumstantially, that she was able to see her husband and able to see her daughter as they passed by the bus stop on Mullen Road. And in the video, 34, there is nothing that's happening at that point. There's been no physical struggle, there's no punches, there's no strangulation. So she pulls into the parking lot, she knows presumably where they are because that's where she ran. There's no testimony that anything that happened beyond those kids is visible. She then runs through cars, sees arms punching her husband's head, goes into the crowd, same time Wagner stops Mr. Ali. She then grabs her daughter. So, in the split second that this all happens, mere presence and knowledge of criminal, more than mere presence and knowledge of criminal activity must be shown. If we're talking also about, self-defense, we talk about mistaken belief, right? Which is somewhat analogous here. There's nothing to suggest that he says, I'm going to kill my daughter, and that was the purpose of going to the school. So, there's nothing to suggest, again, that solicitation, command, encourage, request. The only issue is whether she aided him in attempting to kill her daughter in a fraction of a second, where she arrived with Mr. Wagner and he diffused. There isn't a basis for accomplice liability. Now, the state is also arguing, and I'm not arguing for a halftime motion, as that the actions of my client as she's holding her daughter, the state is alleging assault for them and unlawful imprisonment. And I'm prepared to argue to the jury against that, but to say that she is an accomplice to what happened before she arrived, and in the fraction of a second that she's there, I think is an abuse of the accomplice liability statute and legal theory.
This one line. It's 10:10, a little early, but we'll go ahead and take a recess. I know that from what in addition to the case which was argued by Ms. Stone prior to our recess, I was also provided with State versus Coriel, 197 Washington 2nd, 397, a 2021 case by Judge Dixon from this court. I've read that now, and we'll hear any further argument. Mr. Kading, did you have an opportunity to review those?
I did have an opportunity, Your Honor, and I must admit it's a little confusing given our situation here. But it appears to me that I may have erred in adding assault in the third degree and should have added assault in the fourth degree, so it would appear to be a lesser degree of intentional assault. So I'm going to propose it be fourth degree.
So when you are making that argument, I think one of the distinctions that I want to hear about is these cases, both cases that were cited, discuss that the charge was assault in the second degree. And therefore, they were looking at the lesser and or inferior degree charge. And it is correct that in, at least specifically in the Coriel case, the Supreme Court said that the judge erred when assault in the second degree was charged, and it was charged by strangulation, that the lesser included to that charge would be assault in the fourth degree. In this case, the charge is assault in the first degree, And so I think the differentiation as to what is a lesser included or an inferior charge it's the analysis to assault in the first degree, not assault in the second degree. And so that's, if that makes a difference, that is something I would like to hear argument about.
I read RCW 1061.003. It says, upon an indictment or information of for an offense consisting of different degrees, the jury may find the defendant not guilty of the degree charged in the indictment or information and guilty of any degree inferior thereto. So I don't think that the fact that it's charged first degree limits what the inferior degree crime could be.
Then why wouldn't your assault in the third degree be the correct
Well,
lesser?
we could include
Under that theory.
Well, I think that one of the issues has to do with the mens rea element. I mean, is an element of first degree, second degree, and fourth degree, but not third degree, because that's a criminal negligence standard. And I know in these cases that were cited, there was no, in Coriel, it was a second degree to fourth degree, and third degree was not included. And I think that has to do with the allegation that it was an intentional act as opposed to a negligent act.
So what if I'm looking at Coriel and I have it printed on pages. So I'm on page 12 of what was printed for me. I don't know if you have a printed version. At footnote 50, it says, in sum, we have reaffirmed that the factual requirement for giving a lesser or inferior degree instruction is that some evidence must be presented that affirmatively establishes the defendant's theory before an instruction will be given. The evidence, so I would like to know what evidence, separate and apart from strangulation, has been presented as it relates to the issue of assault, because that goes to the court's consideration.
Well, I mean, obviously there was evidence that he did grab her, and there was evidence in the video that he was touching her and trying to move her from one point to another, which could be considered an assault for these purposes. And regarding the allegations of strangulation, I think again that's something that requires an intent, which I'm not sure has been fully developed in this one.
All right, so just to be clear, you are withdrawing your instructions as it relates to assault in the third degree, and instead are requesting that in addition to the lesser included offense of assault in the second degree, which has been agreed to that there's not an objection to, and from the court's perspective, which is an appropriate instruction, you are requesting that the court give the definition or a elements instruction as a lesser included of assault in the fourth degree.
Correct, as a lesser degree of the initial charge. And I am reading in Brown where it indicates that it would be it could potentially be ineffective if I did not just ask for that to be done. So I am asking for that to be done, and obviously that is my request.
All right. And before I hear from Ms. Stone again, Mr. Leary, this instruction does not apply to Mrs. Ali, but do you have anything that you are going to argue to the court? All right, Ms. Stone.
Thank you, Your Honor. Your Honor, I don't read either case essentially to say that once one charge has been done, we just then include every version of the lesser degree offenses. I understand now that counsel has withdrawn the assault third request and is making the assault four request. As I looked at Brown and as I looked at Coriel, and to be clear, the state provided Coriel to all of the parties and the court. The workman test is the same for each. And looking at the head note 9, at paragraph 48 on Coriel, the Supreme Court there, and I would note the Supreme Court did identify that the issue becomes very confusing at times in application, even if the theory itself is relatively simplified. Implicit within Workman's reasoning is the idea that when there is affirmative evidence from which the jury can conclude that only the lesser included offense occurred, a lesser offense instruction should be given. The court goes on to say at the end of that paragraph, the test was never intended to require evidence that the greater charged crime was not committed, only that a jury faced with conflicting evidence could conclude that the prosecution had proved only the